Hello, everybody.
We can call the matter of Tyler Lagerway.
All right, we have Mr. Tyler Lagerway, cause number 2A0292727. Morning, sir.
Good morning.
This is on for a probation violation. I'm just going to see what it is. Okay. So, Mr. Hooper, it looks like we have a new one actually dated today. It has 2 violations alleged.
That's correct.
All right. So, at this point, Ms. Levine, are you able to admit or deny the 2 violations?
We will be admitting to violation number 1 and then admitting to violation number 2 as to charge only.
Okay. So, Mr. Lagerway, number 1 is just admitted. That was failure to report to probation after a release from prison in January. Number 2, admission only that the charge was filed, not as to the guilt of the charge. With those admissions, Mr. Hooper, what's probation's request here today?
Probation's recommendation is for revocation of probation and 180 days.
Okay, let me take a look at.
Oh. We have set appointments as the recommendation. Mr. Lagerway has indicated that in between being released from prison, he was there for about 10 to 11 months, and then connecting with his DOC supervisor, county probation just sort of slipped his mind. He is willing to set appointments, fully comply, do any sort of treatment or evaluations that are necessary, and would be willing to set appointments as soon as today, go in today. And
So I guess there's a couple of different ways we can move forward with this. Given the fact it sounds like there was a little bit of a miscommunication here, I would be fine withdrawing the admissions and just entering them as denials if you need some additional time to talk with Mr. Lagerway. I guess the other question I would have, Mr. Hooper, is there any version of reality where probation is still willing to work with Mr. Lagerway?
Well, it looks like he's picked up new charges. He's still being monitored by DOC. There's a possibility he might be going back into custody on DOC. So his probation officer indicated that she felt that this should be over.
Okay. So let's do this, if you're fine with it, Ms. Levine. Well, let me clarify. Are you prepared? It sounds like that is probation's recommendation from what Mr. Hooper has said. The probation really isn't willing to keep working with Mr. Lagerway. So do you want to proceed today with potentially a revocation, or do you want some additional time to speak with Mr. Lagerway and maybe we can change this to a couple of denials and set it over in the next week?
let's take a couple of moments just so that we can chat, if possible.
Do you want to just put it today, is what you're saying, and then recall the case?
Yes.
We just have like 2 seconds.
Just 1 second.
Okay. All right. Just make sure you're muted so I can't hear you guys. You are still muted over there. Just so you know, counsel. I don't know if that's still intentional or not.
Thank you, Your Honor. So in Mr. Lagerway's case, I understand that he's admitted the violations. What we're going to be recommending as for a sentence, as for a sanction on probation is he would like to not revoke his probation at this point. He'd like to be able to have the opportunity to set appointments with probation and comply with it. Mr. Lagerway also is planning on going to inpatient treatment to get some structure in his life. And this is a situation where it looks like he was in DOC for the last 10 or 11 months, and when he was released, he went and checked in with his DOC officer, but appeared that he didn't realize that he had to meet with county district court probation as well. I think given that situation especially, and it's generally our intent, if not, it's generally our intent to not double people up on probation like that when they have DOC. Just ask for Mr. Lagerway to have a second chance here before we take the extreme measure of revoking somebody on probation when they're already being monitored by DOC.
All right. Thank you, Mr. Smith. And Mr. Smith, I realize you were in the attorney room, but I did ask Mr. Hooper if probation was willing to continue working with Mr. Lagerway, and probation essentially indicated that they didn't believe it was appropriate at this time, and they're asking for revocation either way. Just so you're aware that that's where we're at.
I understand that, Your Honor, and thank you. I certainly appreciate that, and I certainly understand probation's position here. I think that it's a little different for Mr. Lagerway's situation, where it's not like he was on warrant status, just in the community doing whatever for the last 10 or 11 months. I mean, he was in the custody of the state, and when somebody's in the custody of the state and is unable to comply with their county district court probation conditions because they're in the custody of the state, I think that merits at least some leeway. Thank you.
Okay. Well, Mr. Lagerway, I reviewed your criminal history. I don't think there's any way for me to say it other than this is one of the worst DV histories I've ever seen. I counted 21 prior domestic violence convictions. So you are on very thin ice at this point. I think the only way I'd even consider allowing Mr. Lagerway to remain on probation, I think minimum probably a 20 or 30-day sanction at this point, and then see if he can actually follow through with what he needs to do. So I understand probation's position, Mr. Hooper. If I were to order, perhaps I would say, honestly, I think about a 30-day sanction and then give him one opportunity. Would you have any strenuous objection to that?
No, we'd be okay with that.
Okay, Mr. Lagerway, usually this kind of sanction is probably around the 5-day mark. I'm going to be completely blunt. Your history is so bad. I think that 30 days is more than warranted here, and I'm going to order that, but I will give you an opportunity to stay on probation. So instead of sitting out 180 right now, sit out the 30 days, report to probation, and then at that point, do what you need to do. And hopefully that's the only time you're going to have to serve on this.
All right.
Okay? So give me just a minute to fill out the order, and then I'll be right back with you. Mr. Hooper, do you want to set a review at this time, or just review as necessary?
Let's review if necessary.
Okay. Okay. Order reads basically exactly what I already said, Mr. Lagerway. We have violations 1 and 2 admitted. Number 2 is this to charge only. Continue on probation. It really is your only chance here, I think, given your history. Probation's request to revoke today is denied. I'll go ahead and allow you to continue on as requested by defense counsel. However, I am ordering the 30-day jail sanction. You'll be PR'd on this once the commit's served, and then you need to report to probation immediately upon release from custody. We'll review as necessary. I'm not going to set another date at this point, so the ball is really in your court. You just got to do what you got to do, and if you don't, I think 180 days is probably the minimum the court would consider on a revocation, given the history that you have. So just beware that that's where we're at this point. Do you have any questions for me, sir?
No.
Okay. It's ready for signature, Mr. Smith.
Thank you, Your Honor. And Mr. Lagerway, I'll just mark it in court for your signature, if that's okay. All right, we have signed off.
Thank you. All right, sir. Thank you very much for your time and your patience with me. Good luck. Just make sure to check in with probation once you're released.
Sir, in the Nisqually Jail, good morning. You are John Leroy Landers.
Yes, Your Honor.
Good morning, Mr. Landers. You are before the court under 2 different cases, 25L000545. Actually, that's the only case you're in front before the court on. And that is a first pretrial conference. Ms. Arnold, how would you like to proceed with Mr. Landers' pretrial conference at this time?
Yes, Your Honor, the parties have come to an agreed upon resolution, and that is entering a guilty plea on criminal trespass and resisting arrest in exchange for dismissing the theft in the 3rd degree. That has been uploaded for your review. It includes 12 months of jurisdiction and a couple conditions and getting credit for the days that he's served in custody. And I have gone over all of his important constitutional rights that he is waiving by entering a guilty plea today.
Thank you very much. Mr. Landers, can you hear me okay?
Yes, Your Honor.
All right. Sir, I have in front of me a document entitled Statement of Defendant on Plea of Guilty. Did you read this document or did Ms. Arnold read it to you?
I believe she read it to me.
Okay. Did she answer all of your questions?
She did. Amazingly.
You are 31 years of age and you've completed a GED. Is that correct?
Yes, Your Honor.
This document indicates to me that in this case, you're asking to change your pleas to pleas of guilty to the crimes of criminal trespass in the first degree and resisting arrest. In exchange for that, the city has indicated that they will file or bring a motion to dismiss the remaining count, the charge of theft in the third degree. Is that how you understand you are proceeding this morning?
Yeah.
Have you spoken with Ms. Arnold about the elements of the two crimes that you're pleading guilty to, criminal trespass in the first degree and resisting arrest?
Yes, Your Honor.
You understand what the city would have to prove if those two charges proceeded to trial?
Yes, Your Honor.
You understand that you're giving up a number of constitutional rights by entering a guilty plea. Have you discussed those rights with Ms. Arnold?
Yes, Your Honor.
And you're willing to waive those rights?
Yes, Your Honor.
It appears the prosecutor is going to be recommending 364 days in jail, 354 days suspended in each of these two counts, $5,000 fine suspended, a suspension of suspended sentence for 12 months on condition that you receive credit for time served, commit no new crimes, and have no contact with or go upon the property of the Target store. Is that your understanding of what the city is going to be recommending?
Yes, Your Honor.
And you understand that's just a recommendation. The court is not bound by that recommendation.
Yes, Your Honor.
You understand that if you're not a citizen of the United States, these guilty pleas could have negative immigration consequences.
Yes, Your Honor.
Paragraph 11 asks you to state in your own words what it is that you did that makes you guilty of these two crimes. That statement reads, on March 10th, 2025 in Lakewood, Washington, I did knowingly enter or remain unlawfully at Target. On the same date, I did intentionally prevent or attempt to prevent a peace officer from lawfully arresting me. Is that a true statement of what you did that makes you guilty of these two crimes?
Yes, Your Honor.
Mr. Landers, has anyone threatened you or made any promises to you to get you to enter this plea?
No, Your Honor.
You're doing this of your own free will?
Yeah.
All right. Mr. Landers, to the crimes of criminal trespass in the first degree and resisting arrest, how do you plead at this time? Guilty or not guilty?
Guilty.
Court is going to accept Mr. Landers' pleas of guilty. The court will make a finding based upon the record that Ms. Arnold has made, as well as the court's conversation with Mr. Landers that he's entered this plea knowingly, intelligently, and voluntarily. It appears that he understands the charges he is pleading guilty to, the consequences of those pleas, and based upon his statement, there is a factual basis for both of these pleas. Court will grant the city's motion at this time to dismiss count 2 of the criminal complaint. The charge of theft in the third degree will be dismissed with prejudice at this time.
Cool.
Mr. Graham, anything to add to the city's recommendation regarding sentencing?
Your Honor, I believe Mr. Landers has approximately 9 days credit at this time. But that's the only thing I'd add.
Ms. Arnold?
Your Honor, it looks like he was booked on March 10th, and so I calculate 10 days of credit, but yes.
Thank you. Mr. Landers, is there anything you'd like to tell the court before the court imposes a sentence?
I apologize for my actions. I apologize for having to waste your time. Sorry for your inconveniencing everyone here, and hopefully this will not happen again.
That sounds good to me. I would really like not having to see you in jail. That would be great.
Okay.
So I'm going to go ahead and follow the agreed recommendation. On both counts, I'm going to impose 364 days in jail. I'm going to suspend 354 days. I'm going to give you credit for 9 days that you've already served. I'm going to suspend the entire fine amount. I'm going to order that the 2 sentences in each of those 2 counts run concurrent. So you'll serve both those sentences at the same time.
I do have a warrant out of Grace Harbor and somewhere else. I'm also have a warrant out of Tacoma, but I'm on personal recognizance, and I'm gonna get all that finished out here pretty soon, within the month, hopefully, before the end of the month. So I don't know if they're gonna take me back. I don't know if I don't know. I'm not sure if that's gonna affect anything, but yeah.
Mr. Landers.
I'm not sure. I don't know.
Okay.
Yeah. Yeah. Thank you.
You're welcome, Mr. Landers. I'm just completing that judgment and sentence. Give me just 1 second.
Okay. Young to the fact of justice. The privilege to exist. Give to save one's life.
Okay, Mr. Landers, I have signed that order.
It's all yours.
Sure, you should likely be released later on today or tomorrow.
Okay.
And I wish you the very best of luck, okay?
Thank you, Your Honor. Thank you, everyone.
Thank you.
Be safe, be well, sleep sweet, and much love.